Hi, my name is Deborah Walls and I'm a Senior Associate with the Construction and Engineering team here at Walker Morris. In our previous video guides, we gave you an overview of the adjudication process itself. If you haven't seen those videos, please do check the adjudication page on our website. You will also find there our monthly bulletin, Adjudication Matters, with a roundup of recent cases. Today, I will be talking about mistake in an adjudicator's decision. If you have been through an adjudication, you will know the process can sometimes involve lengthy technical documents and detailed recalculations of payment applications. When adjudicators only have a short space of time to formulate and deliver their decisions, mistakes can be made. However, those mistakes can have a large impact on the result, particularly if it involves detailed calculations. In considering how to correct mistakes, it's important to remember that the law in this area is different, depending on whether the right to adjudicate is written into the contract or if the contract is silent on the adjudication process as a means for dispute resolution. The procedure for dealing with mistakes is called the slip rule. Where a contract remains silent on the right to adjudicate, paragraph 22A subsection 1 of the Scheme for Construction Contracts 1998 applies. This allows an adjudicator to remove a clerical or typographical error arising by accident or omission. It also makes it clear that this can be done on the adjudicator's own initiative or at the request of one of the parties to the adjudication. Under the scheme, any correction has to be made within 5 days of the decision being made, and in England and Wales, the corrected decision must then be delivered to the parties as soon as possible after correction. In Scotland, this 5-day rule does not apply. Where adjudication is written into a contract, the Construction Act 1996 applies. The Act was amended in 2011 to introduce a slip rule at section 108(3)(a). This states that a written contract must contain provision for an adjudicator to correct his decision to remove a clerical or typographical error arising by accident or omission, and this provision must also be in writing. An important distinction with the scheme is that the Act does not specify a time limit for the correction to be made, so the parties are free to agree their own timescales in contract for correction of an error by the adjudicator. For example, in the case of PP Construction Limited against Jeffrey Osborne in 2015, the parties had agreed in their contract that a correction of the slip rule could be requested within 14 days of the decision, following which an amended decision, if required, could be provided within 7 days of the request. Prior to the statutory coverage, the position was dealt with under common law. There are now various well-established principles which flow from case law as a result. When correcting errors, adjudicators must give effect to their first thoughts. They can't amend decisions simply because they're having second thoughts on the matter. This can explain why adjudications are sometimes considered as administering rough justice, which my colleague Juliet mentioned in her recent video bulletin. Adjudicators simply cannot revisit their decision on the merits of the dispute. In the case of Bloor Construction UK Limited against Boma and Kirkland Limited in 2000, the court reasoned that it was necessary to imply a term into the contract which enables an adjudicator to correct a genuine or accidental error within a reasonable time. In the case of CIB Properties against Burst Construction, heard 4 years later, the court made it clear that the ability to correct a decision would have a very limited and narrow application to give effect to an adjudicator's first thoughts. This was reiterated in 2009 in the separate cases of O'Donnell Developments Limited and Buildability Limited, and of YCMS Limited and Grabiner. In YCMS, the error in the calculation was raised on the day the decision was issued. The adjudicator corrected the calculations, but used a different method to reach his decision, and as a result of which he then introduced a further error into his decision. The court found that the adjudicator was not entitled to do this and could only correct the error in the maths using the same underlying basis in which he reached his original decision. Furthermore, any such error needs to be corrected within a reasonable time. In reality, this means promptly following release of the decision. This is important to ensure that the decision still gives intent to the adjudicator's first thoughts, and also to assist cash flow, which is the primary purpose of using adjudication to resolve disputes. Another development from common law is that a consequential correction is permitted where correction of one error means that other corrections or adjustments in the decision need to be made as a consequence of that. An example of this is best demonstrated by the case of Axis M&D UK Limited and Multiplex Construction Europe Limited in 2019. The adjudicator made an error in its calculations, and that error led to a decision that no money was due to the referring party. The error in the maths was pointed out and adjustments made to the calculations, in consequence of which the correction meant the referring party was owed in excess of £650,000. Onto this was added interest and adjudicator's fees, all payable by the responding party. The responding party challenged the amended decision, but the judge ruled that the errors in the maths were gateway errors. Corrections required which had to follow where those figures relied on earlier calculations being correct. This position has also been adopted in arbitrations, as the case of Gannett Shipping Limited and East Trade Commodities demonstrated. The court ordered the consequential corrections in an arbitrator's decision would be necessary to ensure the decision was internally consistent, but it must be a genuine slip, which had failed to give effect to the adjudicator's first thoughts. In Rock Building Limited and Celtic Composting Systems No. 2 in 2010, the scope of the slip rule was clarified. The Technology and Construction Court will enforce a decision where the adjudicator has answered the right question but in the wrong way, but it won't enforce a decision where the adjudicator has simply answered the wrong question. For more on enforcement in adjudication, please see my colleague Seamus's video. In the case where one party has reserved the right to challenge the jurisdiction of the adjudicator, that party can be deemed to have waived its rights to challenge the decision if it seeks amendment of an error in the adjudicator's award. The courts have referred to this as a party blowing hot and cold. A party cannot, in one breath, challenge the jurisdiction of the adjudicator, and in another suggest the decision is correct by inviting amendment of an error. There have been a number of cases which have dealt with this point. In that event, the party raising a jurisdictional challenge must first reserve its right to maintain that challenge before seeking to correct an error in an adjudicator's decision. If it doesn't, a court is likely to find that party has accepted the adjudicator's decision and waived its right to object on the grounds of breach of natural justice. When spotting an error in a decision, it is not necessary for an adjudicator to hear from both parties before making the correction. One or other party can raise the error in the decision, or the adjudicator may spot this themselves, but in any instance, once the error is alerted to the adjudicator, they have the power to correct that if it is a genuine mistake or omission, and so long as it still gives effect to the adjudicator's first thoughts. I mentioned previously the time limits for seeking correction under the scheme in England and Wales, i.e. within 5 days of the decision. This does not apply in Scotland. In practical terms, therefore, a party should check the written contract, the adjudicator's appointment, or the relevant applicable adjudication rules to ascertain if a time period has been laid down in order to deal with corrections. Care needs to be taken to be clear what the mistake is that is being alleged and to see that it falls within the slip rule. If you are an adjudicator, it is important that you review your decision carefully. Make sure that any mistakes are corrected and calculations checked before releasing the decision to the parties. To coin a construction adage, measure twice, cut once. It is more favourable to have a decision released which is correct than face a challenge that any subsequent correction of an error does not fall within the slip rule. If you are a party to an adjudication, you should always check the decision carefully as soon as it is released. Ensure that any error spotted is brought to the attention of the adjudicator and the other party either within 5 days of the decision, if the scheme applies, or within the time limits provided for under the contract or the appointment. If you do find yourself facing a decision which has been corrected, take care to consider how that correction has been applied. If the correction changes the underlying basis on which the adjudicator made their decision and goes beyond simply typographical or mathematical corrections, then there may be every reason to challenge that correction. Of course, each case will turn on its own facts, and therefore if you are in any doubt, please do get in touch with our construction team here at Walker Morris for further advice. I hope this video has provided you with a flavour of the points to look for in the meantime. Thank you.